What is a testamentary trust? Let's get a brief summary as to what it is, what the benefits of it are. Can the courts overrule what you say in your will, in the guidance around finances? Is there a limit in terms of what you can put into testamentary trust and also how long they last? Welcome everyone to another episode of Sue Me Later. I'm joined here today by Tara Lucke, the Queen of Wills at the Art of Estate Planning. Tara, thanks for coming on the show. It's great to chat with you.
Oh, it's such a pleasure. Thank you, Hader.
The art of estate planning. I know it's such a huge kind of topic, but before we get deep into it, tell us a little bit about the origin story, about how you ended up in wills and estates and why you thought this was the career progression for you.
Great. Well, so my background is I'm an estate planning, tax, and asset protection lawyer. But at the Art of Estate Planning, I don't provide legal services to the general public. Rather, we provide precedents, which is like will templates, mentoring, and education to support other estate planning lawyers.
Okay, so you're like a lawyer that helps other lawyers.
Exactly.
What originally got you to get into that particular area of law? Like what fascinated you about it and what kind of drew you to it?
I'd probably say it was just firstly a coincidence. I have an accounting degree as well, so I did the double degree law and business at uni. So I always thought I wanted to be in an area of law that utilized both degrees. I tried out in corporate law. I was very lucky to get a graduate position in a full service firm where in your first sort of like 18 months, they rotated you through different practice areas in the firm. So I did a stint in corporate law, which I enjoyed, but I really didn't like how out of control you were unless you were a partner. It was sort of like, when a deal is happening, it's all systems go. You're there all night. Too bad if you've got, your cousin's wedding, you have to work all weekend. And I felt like a very small, inconsequential piece of the puzzle. And then my next rotation was in an area, we called it structuring, but we dabbled in estate planning, tax, asset protection, and working with private clients instead of big corporates. And that's where I actually really loved just working with smaller clients, having that direct relationship. As an estate planning lawyer, you have the immense privilege of getting to learn about a person's family, a sticky beak at their finances and their wealth accumulation, and just really have a deep personal connection to help them build their legacy. That really resonated with me in terms of my purpose as a lawyer, and that's where I stayed.
Amazing. And I can completely see that because there's different aspects of law. And I often talk to people about this. And really, you've got to find the sphere that suits your personality. Are you someone that wants to be more behind the scenes, at the front of the scenes? Are you a public speaker? Are you not a public speaker? Do you want to get involved in people's intimate moments of their lives? Some people do, some people don't. Some people don't want a part of it at all. And
Yeah.
so, you've got to find what works for you. And I think that's why those kind of systems where you have rotations and you're able to trial things out, especially when you're a graduate lawyer or you're still coming into the law, it makes things so much easier because you can find, okay, this is my personality type and I like to go and do these types of things. And estate planning, like you said, it's very intimate. You get to know your clients really well. You have a close relationship with them and you're helping them through something that is they've probably thought about and put off many times in their lives. There's no kind of like deadline, I think, when it comes to estate planning. And I think that's one of the interesting things about it. There's no like, oh, this is the cutoff date and you need to do your estate planning by here. It's open-ended. And with anything that's open-ended, it leaves all that room for flexibility for people. And so that means they can just keep putting it off and putting it off and putting it off. So what do you see as the kind of key moments in a person's life where they think, you know what, it's time for me to sit down with an estate planning lawyer. I've put it off for the last, X amount of years. Now it's time. What are those kind of key moments? Do you think it's like birthdays or is it like an event or something like that? What do you think?
Yeah, you're absolutely right, Hader. Estate planning is not urgent unless it's extremely urgent. And so you really swing from one end of the spectrum to the other. There's definitely key events. So entering a new relationship, leaving a relationship, having children, making big asset acquisitions or starting a business. And a lot of people, we're very understanding that estate planning is not the funnest thing to spend your money on, but also at the same time, the importance of having the peace of mind and being able to sleep at night knowing that you've protected your loved ones and you have a legacy plan in place is just priceless. So, I find a lot of people, they might be thinking about it for a while, which is completely understandable. But there comes a time when they just go, you know what? I'm really ready to get this peace of mind in place. So a bit
Yeah,
like, doing your tax. It's like, ugh, who wants to
yeah,
do that? And who wants to pay the money? But then, once you've done it, you're like, great, I'm caught up. I'm good. Like, or
yeah,
going to the
that's it.
dentist, it's exactly the same as just you're like, actually everything's fine. Don't need any fillings this year. And I can just enjoy, move on and enjoy knowing I've got that covered.
Yeah, it's not like you're buying a holiday to the Gold Coast with that money, but there's a bit of a deeper satisfaction. I guess that's what you're saying. But again, I think then it's only appealing to a certain subset of people. Like when I say that, not a certain subset, it is still a large group of people, but you've got to be somewhat proactive, responsible, and thinking about the others around you, and you've got to have that type of personality type in order to be estate planning. Otherwise, if you're somebody that likes to procrastinate, put things off, a little bit careless, it's unlikely that you're going to come through the door. Do you think that's a problem, or do you think that's something that can be changed? Because even like that example that you said with the taxes, if you don't do your taxes by a certain point, then the ATO is going to come knocking, there's penalties, there's interest, and you kind of know that. So you don't want to have to deal with that. So there are consequences. But with estate planning, there's no consequences for you. There's consequences for others. But and so that's why I think, is there anything that we can do to kind of change that, or any kind of prompts that we can give people out there?
Look, I would say historically, estate planning professionals get pretty low marks in terms of making the estate planning process appealing. It's always very boring and an unsexy area of law. One of the things that we teach in the art of estate planning for our members is putting your message out there constantly in an accessible way to everyone. So social media is a really great platform. If you have a profile on social media and you work in estate planning, just make sure you are regularly showing up and talking about what you're doing for your other clients in a really accessible way, because everybody needs an estate plan. And in fact, everyone has an estate plan. The government gives you one. It's rarely suitable and it rarely achieves your objectives. So actually undertaking your own estate plan can be really empowering to make sure that what you want to happen when you die or lose capacity actually happens, rather than leaving it to the government. So I find that a lot of the people in the art of estate planning community, the lawyers there, actually, they might spend a lot of time training or educating their audience so that they actually go, oh, I really understand why I want to do this to empower myself. A perfect example, and for you and I, we've both got young kids. Your estate plan is your last act of love for your children. It's the last thing that you do to set them up. And whether your children are adults or little, whether you leave a mess or you set them up in an environment that is tax effective and protects their inheritance, it can just make such a difference to their future. And it really is your last act. So a lot of people, once they understand it through that lens, they're like, oh, this is not just a piece of paper. This is
Yeah.
my life's legacy.
It's a beautiful lens to kind of look at it, definitely. If
Mm.
you look at it through the lens of your kids and what you're leaving behind, because what 99% of people that have kids out there, they're going to work every day and they're thinking, I'm doing this for my kids. I'm doing this to set them up, right? Like once you have children, that's your lens and that's your perspective.
Yeah.
And so, there's a huge piece of the puzzle missing if you haven't got your estate plan in place and you think you're doing it for your children's future. I like that angle. I think that's a bit of a wake up call for people. So let's get a little bit deeper into estate planning. Now we know what can, I guess, motivate people to get their estate plans done. Let's go into the concept of like, what is an estate plan? Okay, because people think, I think generally out there that, oh, it means I've got to do my will. And that's kind of the first concept that comes to people's minds. Can you go a little bit deeper on that and help me out here?
Yeah, absolutely. And if you sort of start Googling estate planning, you might actually come across some of the online will providers who have excellent marketing and do a really good job. I will give them A+ for their communication and marketing, and they are selling a will. So you're like, great, I can get a will for $99 and I'm covered. And it breaks my heart because, those types of providers, they're not law firms, they're not giving you any legal advice, but they are also lulling you into a false sense of comfort that you are covered.
Yeah, I got to jump in here because I literally was at the post office the other day. I was lining up and I was waiting to send off my parcel overseas. And as I was lining up, I looked to my left and I just saw a DIY last will and testament kit. I think it was $25. And I was just thinking, wow, I can't believe they're selling this. Like this is, I thought we're beyond this. You kind of hear jokes about it a little bit in the legal profession, but that's a huge liability, to have something like a product out there which isn't going to provide anywhere close to the required advice for everyone, really.
Yeah, no, it's concerning, and there's just a lot of lack of awareness. And what frustrates me is that people go out there and they think they're doing the right thing, and good on them for being proactive, and they're being led astray. So
Yeah.
when it comes to a comprehensive estate plan, I almost like to picture, and actually shared a graphic of this on my socials today. A rope, like a strong, thick rope, and a strong rope is actually made up of several strands, right? It's not just one strand. And all of those strands together is what makes it strong and able to, complete the task that you needed it for. So, in a comprehensive estate plan, of course, the will, which we've always talking about the will, and that's a great place to start, but that only covers dying. What we want to also protect for is if you are still alive, but you have lost the ability to make decisions for yourself. So you need someone to step in and make either your medical decisions and lifestyle decisions, like where you're living, what care you receive, what particular medical procedures you go through, and then also someone to manage your finances. So those are generally sort of called enduring power of attorney. Every state calls them something different, but like a sort of general term is kind of like power of attorney. So I really encourage people to make sure they cover off death and incapacity. There's also a really big misconception about our money in superannuation. And for a lot of young families who are still in the process of building up their wealth, when they die or if they die young, most of their money is in their superannuation fund because they get a default life insurance policy when they have a job. And your will doesn't cover that automatically. So you can either make a special nomination and have it come into the umbrella of your will, or you can just make a nomination and direct that it goes directly out to particular loved ones. So that's called a death benefit nomination. So it's really important that you have a nomination in place for your super, or at least a strategy. Like, not everyone needs a nomination, but most people do. So you want your estate planning lawyer to look at that and tell you what the right plan is for you. And then there's other aspects as well. Like, I call it a letter of wishes, but it can be anything. Just basically guidance from you to your loved ones and the people who will financially control your estate about where everything is, even how to get into your house, what bank accounts you have, how to access your digital assets, information they need to know, like whoever's going to be the guardian of any minor children you leave behind, like who's their doctor, what are your wishes for them. There's a lot of more practical guidance that can really help make your estate plan work beyond like the pure legal framework. And then lastly, actually the funding piece. So making sure there's enough money that you're leaving behind. So for me, I am still in the wealth building phase. So my husband and I have a lot of life insurance that we're leaving for our two boys, so that I know like all our debt will be paid off if one or both of us die. Like, if my husband dies, I don't want to be saddled. Well, we've got a huge mortgage. I don't want to have the pressure of that all on my own when I probably am going to have trouble just getting out of bed. making breakfast for the boys, let alone having all this financial pressure and being the sole breadwinner. Someone have actually talking you through, well, what money is there going to be, and do we need to actually bring in some like life insurance or something just to sort of achieve your objectives when you die?
Basically, there's a whole heap of things that need to be considered, and you'd be getting specific advice around, as opposed to here's a document and do your will,
Yeah.
and who are you going to leave it to? There's so many things that need to be considered holistically in order to have a good estate plan, and that's why it's called estate planning, and it's not called do your will or here's your estate
Yeah.
document. It's a whole plan that you have to have in place. It's constantly evolving based on your situation, based on what's going on with your life events, with your financial situation as well. It's always moving forward, it's always evolving. I guess that's why you've used that kind of terminology, the art of estate planning, because it's constantly moving. I want to kind of touch on some of those points because you would know more than me. There's a lot of misconceptions out there when it comes to estate planning. Okay, it's probably one of the areas of law, I think, which is riddled with the most kinds of myths and
Mm.
misconceptions, because as you said, it touches on everyone, so everyone's got an opinion on it, and they've heard something from their grandma's cousin who told them, if you do this, then you've got to hide a voodoo doll next to your will in order for it to be authorized by the courts or whatever it is. There's so many different things that I've heard out there, but I want to touch on some of the big ones. First one, kids. So you mentioned in your letter of wishes that there can be something in there in relation to children. Is that the most suitable place for your intentions in relation to your children? And how would that be viewed down the line in the event that you do pass away and you have kids that are under the age of 18?
A common misconception is that if you've named godparents for your kids, that they just become the guardians, which is not the case. And in fact, you can, and we encourage clients to put in their will a nomination for who they want to be the guardian. So that person is responsible for making decisions on behalf of the children and their well-being. That can actually be overridden by family courts. So especially if you have, you're not with the biological parent of the children, basically you can put your wishes down. The court can override that to make a decision that they think is in the best interests of the children, which I think is as it should be. They assess the situation at the time.
Yeah. I speak to quite a few people about this, Tara, and I think people are a bit shocked. I think when they first hear that, they're like, what do you mean I can't tell my future people that, these people should be in charge of my children? And I think that is quite confronting for a lot of
Yeah.
people because they feel like they're in power and they should have the ability to nominate who they want. But when you explain it and you kind of break it down, there's so many things that could be wrong with that. Like, is there another parent that's alive? Maybe they should have priority. If you've nominated, for example, your parents, are they still alive? If you've nominated a sibling of yours, maybe you've had a falling out with a sibling, maybe the sibling hasn't seen the kids in years. There's so many things that can kind of go into it, and you don't know exactly what the circumstances are going to be at the moment of your death. And so that's why it's something you can put forward, but it can be overridden if it's not going to be the best thing for your kids. And I always find that quite an interesting thing, and people can find it a little bit confronting when they hear that.
And if we do get that feedback from a client, there's things that we can do. Like the number one thing I would actually say to them is we may not have total control over who takes care of the kids. The court can supervise that and say, well, actually, considering everything, we have assessed that this is in the best interest. But one thing we can control is who is in charge of the inheritance for the kids. So we can nominate the people that you want to actually control the money that you leave for them. So
Yeah.
particularly if you are not with a biological, a parent, like say you've separated from the parent of your child, sure, your children might have to live with that surviving parent, but you can nominate who is going to run the money for them. So you might nominate, one of your siblings or your parents or your best friend so that at least your ex is not in charge of controlling that money and making decisions. So you've sort of still empowered and that someone you trust is there, maybe they're drip feeding out the money or paying the bills directly to the school or the swimming academy or whatever it is so that you're not just handing everything over to your ex.
I feel like you've heard these things before and you've given these guidances before. It sounds like you're well versed and you're ready to go because it's a great response, basically. You can still provide power and guidance in a different way. It might not be the way that you first envisaged, but that's actually quite powerful in terms of who's got the financial strings
Yeah.
to the purse, right? Similar topic, and that is another objection, which is, can the courts overrule what you say in your will, in the guidance around finances? Is it something that can be prevented altogether? Because you look at the news any given day and there's probably a story in there about some rich family where there's an inheritance battle and somebody got this and they challenged it in court and then a will got overturned or something like that. So I think that doesn't do wonders for the PR relationship for people and their
Mm.
wills, because these types of disputes are in the spotlight.
Yeah.
So what do you say normally as a response to that?
Absolutely. There is a principle of, they call it testamentary freedom. So you should be free to make your will however you like, but it can be challenged with, which really can rub people the wrong way, as you say. They're like, this is so unfair. So there's a couple of things. Firstly, not everyone can challenge a will. You have to be in a certain class of people who have a particular relationship with the will maker. So, I can't just come and challenge your will, Hader, because
Mm.
I'm not financially dependent. I'm not related to you. So, I don't have standing. But, a classic example is like leaving out an estranged adult child from a will.
Yeah,
And you
yeah,
say, I only want to provide for two of my three children.
yeah,
Well, that third child could bring a challenge to say, I haven't received adequate provision from the estate. People do get upset. And I even talk about it if we're watching TV and I talk about it with my husband. He's like, God, that doesn't seem right. And I'm like, well, no, it's that you're coming at it from a perspective of what does that child owe to how have they conducted themselves? Have they behaved poorly? Are they deserving of the inheritance? Unfortunately, the policy behind the legislation that the government has created, allowing people to challenge wills, is not about merits. It's about trying to stop people from being a burden on our social security system. So they want to shift that burden to will makers rather than themselves. So if you're needy, even if you have a history of maybe blowing your every dollar you've ever earned, if you are needy and likely to be a burden on the government, then you probably are going to be able to show to the courts that you deserved something. Now, that's why you need to work with an estate planning lawyer,
yeah.
because a lot of the time there's things that we can do to try to minimize the assets that are available to satisfy any kind of challenge.
Yeah, I love that word, minimize. It's
Yeah.
perfect.
Look, we
Because
can't make it
there are things that you
bulletproof.
can do.
Yeah. You're in New South Wales or
Yeah,
Victoria? Yeah.
big New
So
South
New
Wales.
South Wales has its own rules, and it is a lot harder if you're in New South Wales compared to some of the other states. So I can't sort of sit here and go, oh, we'll sort it out for you. Don't have to worry. But there are things that you can do because there's structures like joint tenancies, putting assets in like family trusts, having your super go directly to beneficiaries instead of into the estate. Some of those types of strategies can help make sure that the pool of money available up for challenge is actually a lot smaller. And sometimes, there's actually nothing that comes under the will, and these other strategies can't be challenged. So it's a case by case. It will really depend on your circumstances, but that's where, a good estate planning lawyer really shines, and it's worth sitting down and getting their advice so that they can try to give you that comfort.
All right. Well, let's move to the hot topic of the month, or maybe it could be the year, and that's testamentary trusts. This has been in the news a lot. There's been a lot of discussions about it. It's probably a word or phrase that nobody has, I would say less than 1% of Australian society has thought of / cared about in the last 100 years. But for some reason, it is in the headlines. Testamentary trusts. Okay. So, quick summary. The reason why it's in the headlines is because of the changes that the Labor government has proposed in the budget. I think that there were in May 2026. I think the changes were proposed. There's still a little bit of discussions from what I understand as to what's going to happen with testamentary trusts. But let's get into it because I know it's a topic that you're really passionate about, Tara, in terms of having a testamentary trust in the first place. So let's take it from the start. What is a testamentary trust? Let's get a brief summary as to what it is, what the benefits of it are, what the proposed changes are going to be like, and do we still need them, I guess, in 2026?
So, yeah, if you look at any of the sort of content or information I put out there, I am always banging on about testamentary discretionary trusts because I think they're really powerful as an estate planning tool. They change lives for young families. So, essentially, what it is a discretionary trust established in a will. So if I died, instead of leaving everything like straight to my husband, instead I leave it to a trust set up in my will that my husband perhaps controls and he runs it for himself and our kids. Now that trust, I've got a will which says that trust doesn't start until I die. So it's sort of sitting there dormant. And the reasons people would use a testamentary discretionary trust in their will, as opposed to like a basic will where you just leave everything to each other and then to the kids, is it offers incredible asset protection. So from a family law perspective, from making sure that the inheritance ends up with my kids instead of with my husband's next wife, in terms of business exposure, so, bankruptcy risks. They offer some tax flexibility, and, that's probably where we've got the asterisks at the moment. We haven't got any legislation at the time of this recording, just an announcement. They currently offer incredible tax treatment for minor children. And then they're also just really helpful for sort of planning for the next generation of your inheritance.
Is there a limit in terms of what you can put into testamentary trust and also how long they last?
They run very similarly to like a family trust that we might set up during our lifetime. So all trusts can only last for a set amount of time. So, like in Queensland, they recently extended that from 80 years to 125 years. New South Wales, it's still 80 years. South Australia, there's no time limit. With a testamentary trust, that time pretty much starts ticking down from the date that you die rather than the date that you sign your will. In terms of what you can put in there, there's no limit as long as you put the assets. The only assets that go in there are the assets that you owned when you died that get transferred into it under your will. So you
Okay.
can't sort of get one and then just keep chucking
Start
more
adding things into
assets
the
in.
box.
I mean, you technically you can.
Yeah.
The reason people don't is because of the way the current tax rules work. There's a big disincentive for doing that. Who
Okay.
knows? Under the new rules, maybe that will change.
So even with these new rules, which is only affecting, I guess, that one component of the testamentary trust, which is being able to distribute and save on a bit of tax, essentially, when you're distributing, especially to minors. That's the part that they're playing with. And even if those changes do come into effect, again, asterisk, we don't know if they're going to come into effect. But even if they do, you still see that there's huge benefits in getting a testamentary trust when you're doing your estate planning.
Yeah, absolutely. So if we just sort of round out the tax treatment, so currently minors can receive up to $22,000 of income each year, each minor, from the income the inheritance generates, and that's tax free. So,
Yeah.
I've got two boys. If I die and I've got the $1 million life insurance policy and it earns a 5% return, then of the first like 44,000 of that income can be allocated towards them with no tax payable. And then,
Yeah.
like the 16% marginal rate from there on. So it really just helps young families who have lost a breadwinner make their inheritance go a lot further towards paying for the children. And so it should, because that is income generated from an inheritance. Someone had to die to get this trust in place. You can't just go and set one up and have it
Mm.
running. Like, they only have assets that are inheritance assets, and they can only exist because a person died.
Let's take a step back here because it's a very specific example that you've given in terms of, like what's the, I guess, the flip side example, which is, let's say, the more evil example that the proposed changes are trying to target? Because I don't really see anybody voting in a government to say, yeah, like those kids without a parent, they shouldn't get those tax benefits, of that
Yeah.
$22,000 and that in that hyper specific example where you've got life insurance and then there's an accumulation of that because of the growth in that life insurance, and we should be taxing those kids. That example to me just seems like it's not going to be a very common occurrence, I hope, but even if it is, why would a government be trying to shut down those benefits like, that's horrible. That to me just sounds horrible. Like, why would you be doing that? So there must be a kind of an evil example that the government is saying, these are the people that we want to be taxing, and this is why we're putting this in place. Is there an example like that?
Yeah, so it's currently this tax-free treatment is for all minors. So my children get it, but also when they grow up and inherit the trust, they get tax-free income to their children and their children's children. So it goes through multiple generations. Like, these are why they are such powerful structures and why I'm such
Okay.
a huge fan, because
Yeah.
like, historically, it's been the domain of wealth. If you wind back 20, 30 years ago, the general punter on the street wasn't getting advice and accessing these types of structures. It is the very wealthy who, paid for the best lawyers to get them set up, and then they are just paying less and less tax through these structures for, 80 years, 125 years. So they are very tax effective. They also have the same streaming characteristic as you have with like a normal family trust. So they allow you to allocate the income each year amongst all of the people who are named as beneficiaries in the trust. So you can use up all of their marginal tax rates and overall pay, maybe the average tax rate is only 30% instead of it all being in the name of one person and being a top, the top marginal tax rate of 46.5.
So, the point that you made there, just about it previously being a tool, I guess, for the people that could get the best estate planners before, because there was those tax benefits. Do you see that changing now? And do you think there's been more of an inclination and more of a push for the average punter to be getting a testamentary trust as part of their estate planning? Previously, maybe 20 years ago, it wasn't so much of a thing. And now there's been a push to kind of do that. And have you noticed an increase in those numbers? Let's start off with that.
Well, that's my personal mission at the Art of Estate Planning, to let everyday families know about these structures that are available and to support more lawyers to be able to deliver them to their clients, because they, like every one of my family members and friends who is young and gets married or has a baby, I gift them testamentary trust wills as, their baby gift, because I believe so much about how life-changing they are. Obviously, the tax is there, but they also offer so much asset protection as well, which for me, I think for most people, if the surviving spouse or the child who's an adult who's inheriting the trust is already earning like $45,000 of income from other sources, so like salary or wages or, other investment income, this new 30% tax will actually not really impact on them. They were already going to pay tax at 30% on anything they received from the trust. We're also pretty confident that if you are a minor and you've lost both your parents, that you will still get that tax-free treatment, because while we don't have a lot to go off, there's no legislation, we've just got a few paragraphs in the budget papers, they're saying vulnerable minors are going to be exempt from this new 30% tax.
Okay, that's good.
So, if you've lost both your parents, you should be
And
tax-free.
and
Yeah.
when you put it that way, it just feels like the people that are actually being targeted, it's so limited, like you said, because they were the other people that were going to pay that marginal tax rate above that marginal tax rate anyway. So I don't know. I'm starting to see a bit of futility in this whole exercise.
Yeah, well, I mean, that's my sort of bugbear because I have a feeling, and we're currently sort of advocating and trying to raise awareness for this, with our members of parliament and the government. I don't know that they fully appreciate that there's a real disconnect between what their tax reform policy
Yeah.
is trying to achieve, which is basically, the wealthy not using these structures to get out of paying their share of tax. Actually, what their policy does is penalizes the people who need the protection of a trust, but don't earn $45,000 a year from wages. So
Okay. Well,
retirees, stay-at-home
mm,
spouses, disabled adults.
yeah, yeah, you're spot
Mm.
on. And I like what you're doing, Tara, in terms of trying to democratize this knowledge. And you've taken a unique approach. You haven't gone for a retail kind of perspective where you're helping clients one on one. You've gone for a wholesale approach, and that is speaking to lawyers and upskilling lawyers really, and giving them the support and the resources so that they're able to maximize their impact in their communities.
Yeah.
And I think that's such a unique way of tackling this issue, and giving and maximizing the benefit and the knowledge of these important vehicles when it comes to estate planning. So I think it's an amazing thing that you're doing in terms of getting that information and knowledge out there. Previously, it was kind of locked behind closed doors, and it feels like your push has made an impact. And dare I say it, maybe the number of testamentary trusts has increased as a result of your push, and it's caused a bit of concern for the government to turn around and say we need to make some adjustments, because all of a sudden this tax minimization vehicle, which wasn't very popular before, now has become a bit of a mainstream thing. And I think that's largely due to people like yourself, if not yourself as well.
Yeah, I made too much noise. I mean, the irony is there's only like the numbers reported by the tax office about the number of testamentary trusts out there. There's like 10,000 or 11,000 that are in existence where people have died. There's a lot more. Like I've got them in my will, so a lot sort of in the wings ready when people die, but they're not prolific by any
Yeah,
means.
yeah, that's right. I saw those numbers as well, and I was like, okay,
Mm.
I didn't really fully comprehend that data in terms of there's 10,000 that are active. Um, Not sure how those numbers are kind of looked at or collated, but then how many are sitting, ready to become active at some point,
Yeah.
and so how many people are kind of affected that way. And I would hope, and you would hope as well, that your impact has been so large that those numbers are going to increase, because, like you said, it puts the power back in people's hands. There really isn't many instances where a testamentary trust isn't going to be to someone's benefit. The only problem is a lack of access to them, a lack of information, a lack of education, and you're trying to bridge that gap.
Yeah, exactly. And even with the impact of the potential tax changes with the 30% tax, testamentary trusts continue to provide incredible asset protection, so protecting the inheritance for the people who need it. So I think those numbers are going to continue, and it's interesting sort of talking to the lawyers in my community. They're actually, because we're out there going, they offer, this is how they work from an asset protection point of view. We're actually seeing a higher take up of testamentary trusts since we've started talking about them more.
Amazing. So before we wrap up, Tara, if you can give us a bit of insight, if people are listening and they want to get in touch with you, is it something that you deal with in terms of like the public directly, or are they to get in touch with someone, or one of the lawyers, I guess, that are in the community that work with you? And if you can give us a bit of insight as to who those lawyers are and how they can connect with you as well, I think that would be really interesting.
Yeah, absolutely. So I do not prepare wills. Please don't reach out to me asking me to prepare your will because I'm just going to have to say no. Sorry. If you're a lawyer who is curious about testamentary trusts or wants to feel more confident about delivering testamentary trusts, I'm your woman. Go to theartofestatePlanning.com.au. We have a lot of free resources to support you. We've got the Art of Estate Planning podcast, and we also sell all the precedents and training that you need to get started. Look, and if you do want to get your will updated to include a testamentary trust, you can reach out and let us know where you're based, and I can get one of our member firms to reach out to you. Also, Hader, your law firms also provide this service.
Yeah, yeah, yeah. You can reach out to me, I guess. But anyway, I just want to, last thing, just in terms of the art of estate planning, if you're a lawyer and you're looking for guidance and looking for the support, confidence, resources, precedents, they can come to the art of estate planning. They can reach out to you, Tara, and you can guide them through and get them involved in that part of the community. What does a typical member of that community look like? Like, who are these people that kind of join and want to be part of this community?
Yeah, great question. Look, honestly, we're really welcoming. The main requirement is that you have a collaborative mindset. You want to be part of a community and you are curious about learning. So, we support a lot of experienced practitioners who might be sole practitioners or in a boutique firm who just want to have sort of a brains trust to bounce things off. You don't have time to develop your own precedents or stay up to date with them because you're so busy on the tools. We also support early career or junior practitioners who may not have access to all the mentoring they need in their firm, or they want to diversify their referral network and mentoring. So it doesn't matter whether you have a master's in succession law or you're brand new. If you're a family lawyer, or even we've got litigation lawyers who just go, actually, I need a break from this area and I want to retrain into an area of a law that is more family friendly. There's no conflict, there's no crazy deadlines. We'll support you to get started. Even, if you're in a big firm, we're pretty much a lot of our clients are sort of smaller boutique sole pracs, but we also have people in larger firms who just want to connect with an amazing network. We have over 700 law firms around Australia who use our precedents. We have a membership where we meet every Thursday. There's over 300 lawyers in that group. So it's just a very supportive, collaborative community as well.
Amazing. Thank you so much, Tara.
Oh, it's a
Really,
pleasure.
really appreciate you coming on the show, and good luck with everything. And we hope to hear from you again.
Thanks, Hader. Until next time.